Can employees unilaterally retract their resignation? This is stuff employers should know.
Welcome to Stuff Employers Should Know, proudly brought to you by LabourNet, management's ultimate HR solution.
Hey, and welcome to the podcast. I'm Barry Gordon-Davis, and across from me, sound producer Yasser Yes Like It Ismail. And yes, I just want to let you know that I'm tendering my resignation from this podcast. This will be my last one.
Wait, what? Where's this coming from?
No, hold on, wait. Let me retract that resignation. I've actually decided I'm going to stay on.
Okay, Barry, you were literally 1 foot out the door. What's going on?
Yeah,
Are you here
exactly.
Or you're not here?
So am I here or not? Well, this is the precise situation that a lot of employers might find themselves in, where an employee goes and tenders their resignation only to, let's say, within their cooling off period, or whether they have second thoughts on it, they then decide to actually retract their resignation. So the question is that can they do it without the employer's consent? So this was the precise situation that the Labour Court presided over in the Mohlwaadibona versus Dr JS Moroka Municipality matter recently, where Mr. Mohlwaadibona, at the beginning of April 2021, he resigned from his employment of the municipality due to ill health. On the 10th of April, so you could say 10 days later, the employee was advised by the municipality that his resignation was accepted. However, on the 15th of April, he wrote a letter and stated that his reasoning for resignation had his circumstances had changed. He had resigned for ill health, and he said that he had had a miraculous recovery, and he had effectively changed his mind and wished to retract his resignation or withdraw his resignation, and he indicated that he then wanted to return to work 4 days later. However, the municipality or the employer advised him through correspondence that they did not accept the withdrawal, but the applicant actually, and I say the applicant because it's sitting at the court, claimed that he actually only received this communication on the 23rd of April when he had actually, after issuing his, let's say, correspondence stating that he wishes to retract his resignation, had actually reported back for duty on the 19th of April. So and he was obviously then contesting that they need to accept his resignation, and the fact that they didn't accept his resignation was then a dismissal. So the questions that were before the Labour Court was effectively, what is the effect of a resignation on the employment relationship? When does the resignation actually take effect? Is it at the time that the notice is given, or is it at the end of a period? And mainly, and the main crux of today's session is, can it be unilaterally withdrawn? If not, what is then required to revive the employment relationship? So the court held that by its very definition, a resignation is voluntary, and it's a unilateral act by the employee that puts an end to the employment relationship. And on when does it take effect? The court confirmed that it takes effect the moment it is communicated with the employer, and it is incapable of being withdrawn unless the employer actually expressly consents to it. So even where an employee contractually is obligated to serve a notice, or fails to provide that notice and the like, or fails to honor the obligation of notice, it doesn't have any effect on the effect of issuing that notice of resignation. So to conclude and to really sum up everything, and it's something that was basically just reaffirmed by the courts, it's something that we have known, but they've basically reaffirmed that when an employee voluntarily elects to communicate their intent to terminate the employment relationship, it cannot be unilaterally withdrawn once it has been communicated to the employer. So where an employee is required to serve a notice period, their failure to serve that period or their actual serving of that period doesn't negate the effect of the resignation, as the employment contract will be seen to have reached an end. So the only way to actually revive the contract of employment would be through a fresh offer and acceptance thereof, which is tantamount to a rehiring or reemployment. This can occur where basically an employer then opts to accept the withdrawal of a resignation. So if you want to serve us notice of a suggested topic, get in touch, or even just say hi. Fire off an email to sesk@labornet.com and find us on all the major social media platforms. Please don't forget to subscribe to the podcast on whichever platform you use to hear us every week, and ensure that the subscription notifies you of when new episodes come up so you can never miss an episode on all things labor law. So from myself, BGD, and Yas, who has accepted my withdrawal of my resignation, so that means I'm going nowhere. Till next week, stay safe and cheers.
Stuff Employers Should Know was proudly brought to you by LaborNet, management's ultimate HR solution. For more episodes from Stuff Employers Should Know, go to Apple Podcasts, Google Podcasts, or wherever you play your favorite shows. Case law or statutes referenced in the podcast are current at the time of recording.